In 2008, the Zimbabweans overwhelmingly voted for the MDC T, which was then led by Morgan Tsvangirai in their numbers. And it became difficult for ZANU-PF to rig elections, and Robert Gabriel Mugabe was highly defeated by Morgan Tsvangirai. From the results that actually were not announced. In fact, as usual, the Zimbabwe Electoral Commission decided to announce the cooked results, but a story is not told of how many Zimbabweans died in the process of achieving that. There was so much violence in 2008 whilst ZANU-PF was trying to heal from the defeat of the opposition. An organization in Zimbabwe had actually approached the court in Zimbabwe to compel the government to revisit the atrocities with the mentality of actually ensuring that Zimbabweans get to heal from the past atrocities committed by the very same government that is still governing today. But guess what? ZANU-PF doesn't want to entertain this, as well as the courts of ZANU-PF. Greetings and welcome to your lovely channel, the Hlonipani Global News. If you are watching us for the very first time, please do remember to press the red or black subscribe button so that next time when we beam live, you become the very first one to watch us. So the Zimbabwe court declines to hear a case seeking into 2008 atrocities. The High Court of Zimbabwe has struck off a constitutional challenge aimed at compelling investigations into the 2008 election violence, during which more than 200 people were killed and thousands were tortured or displaced. Hill Zimbabwe Trust had approached the court seeking to invalidate a provision of the Zimbabwe Human Rights Commission Act that limits the Commission's mandate to investigate historical human rights violence. But Justice Maxwell Daguva ruled that the application was improperly before the court, as it had not been brought under the supremacy clause of the Constitution instead of the correct enforcement of provisions. The Heal Zimbabwe, a human rights organization focusing on peace, reconciliation, and political violence, together with Hilton Chironga, had approached the court challenging the constitutionality of Section 94A of the Zimbabwe Human Rights Commission Act, Chapter 10, 30. The provision restricts the Commission from investigating complaints relating to acts or omissions that occurred before the 13th February 2009, or where complaints are made more than 3 years after the alleged violation. The applicants argued that the limitation was unconstitutional, as it curtailed the broad investigative powers granted to the Zimbabwe human rights under Section 242 and 243 of the Constitution. They contended that the restriction undermined the rights to truth, access to information, equal protection of law, and freedom from torture, particularly in relation to violence that occurred during the 2008 runoff elections in Chaona, Mashonaland West. Hill Zimbabwe sought an order compelling the Zimbabwe Human Rights Commission and the National Peace and Reconciliation Commission to investigate alleged killings, torture, and assault linked to political violence in the area. The applicants argued that Section 94A is ultra-vires the provisions of Section 243 of the Constitution of Zimbabwe and is a violation of the doctrine of constitutional legality. Applicant submits this provision is in breach of the right to truth, access to information guaranteed by Section 62 of the Constitution and Section 56(1), right to equal protection and benefit of the law. Read part of the court papers. The Zimbabwe Human Rights Commission, however, opposed the application, maintaining that it lacked jurisdiction to investigate events predating February 2009 due to the clear wording of Section 94A of the Act. The Commission said it would abide by the court's decision. The second respondent is of the opinion that it is the correct position of the law, particularly on the constitutionality of Section 94A of Zimbabwe Human Rights Commission Act. Section 94A entails the jurisdiction of commission to conduct investigations. It stipulates that the commission shall not investigate a complaint unless the complaint is made within 3 years from the date on which the action or omission of that occurred earlier than the 13th February, the court noted. So those who were framing this constitution, they understood, maybe the criminals were also involved. They understood that if they do not put such a clause, they would be in trouble, especially if investigations are allowed to be carried out and the truth gets to be exposed to the people. Parliament of Zimbabwe, cited as the third respondent, also opposed the application. It argued that Hill Zimbabwe lacked the requisite legal standing and had failed to properly frame the matter as an enforcement of fundamental rights under Section 85 of the Constitution. Parliament submitted that the relief sought amounted to a direct challenge to legislation without corresponding declaration of rights infringement. In determining the matter, Justice Taguba identified 4 issues, including whether the applicants had locus standi, whether the application was properly brought before the court, and whether Section 94A was unconstitutional. On locus standi, the court found the Hill Zimbabwe had not demonstrated that it was acting in the general public interest, but rather on behalf of a specific class of victims from the Chaona area. The court held that this required a different procedural approach, such as a class action under Section 85(1)(c) of the Constitution. The judge ruled that although Section 2 of the Constitution affirms constitutional supremacy, it does not provide a standalone procedural route to challenge legislation. Instead, challenges to the constitutionality of a law based on alleged infringements of fundamental rights must be brought under Section 85 of the Constitution. It is my view that the complaint by the applicant on the constitutional validity of Section 94A of the Act should have been made in terms of 85(1)(a) of the Constitution, alleging that one or more of the constitutional rights, Okay, therefore, the application was not properly placed before this court. Justice Taguba held. As a result, the court struck the applicant off the roll, making no order as to cost. The court did rule on the substantive constitutionality of Section 94A of Zimbabwe Human Rights Commission. Hill Zimbabwe was presented by Tendai Biti, while the respondents were represented by the Attorney General's Office, Matsiki, the Attorney at Law, and Chihambakwe, Mutizwa and partners. Zimbabwe's 2008 period was marked by widespread political violence that followed the first round of voting and intensified during the runoff. I think I have said it all. So definitely, what do you expect from we are led and ruled by the killers? Do you expect them to actually allow to be exposed? That is what is happening in Zimbabwe. Thank you very much for watching us. If you're watching us for the very first time, please do remember to press the red or black subscribe button so that next time when we beam live, you become the very first one to watch us. So Kanqobo Mhlabane is signing off. Let me love and leave you.